Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. Eligibility for the death penalty as to Peter Wang. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established as to count 17, Peter Wang. No. October 13th, 2022, signed by foreperson Benjamin Thomas. Madam Clerk, would you please poll the jurors?
Mr. Thomas, is this your verdict?
Yes.
Antony De Vega, is this your verdict?
Yes.
Stephen Crop, is this your verdict?
Yes.
Jimmy Benbow, is this your verdict?
Yes.
Andrew Johnson, is this your verdict?
Yes.
Andrew?
Yes.
Yes. Annette Sanchez, is this your verdict?
Yes.
Stacy Lezing, Jim, is this your verdict?
Yes.
Melody Van O, is this your verdict?
Yes.
Mirel Rinkus, is this your verdict?
Yes.
Dimitri Bahara, is this your verdict?
Yes.
Gabriel Figueroa, is this your verdict?
Yes.
And Denise, is it Conho? Is this your verdict? Yes. Thank you.
Members of the jury, I wish to thank you for your time and consideration in this case. I also wish to advise you of the following. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. Your deliberations, discussions, and votes should remain your private affair if that's what you wish. Therefore, the law gives you the privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you're also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. At this time, the sheriff's office is going to escort the jurors out of the courtroom. Okay, the defendant having previously been, has he been adjudicated of 17 counts of murder in the first degree, the jury having returned a verdict of life imprisonment without the possibility of parole. Is there any legal reason why I should not impose a sentence at this time?
Yes, Your Honor.
Okay.
And that is under 921.143, the victims under counts 1 through 17, and also the surviving victims of the attempted homicides have a right to express themselves as to the everything that could not be expressed under victim impact. They can express themselves as to crime and what they think should have been the appropriate disposition and sentence. It is anticipated that that could be a lengthy sentencing hearing because it applies to all 34 counts of the indictment.
Okay, are you prepared to present that testimony now?
No, we're not, Your Honor. And under the statute, it says that The victims have a right to present that testimony, and also, as you know, under the Florida Constitution, the victims have a right to be heard, and that the victim should present that testimony before you announce sentence.
Okay, when, can we do that on November 1st, which is a Tuesday?
Yes, Your Honor.
Okay, I'll reset the sentencing for November 1st, Tuesday at 9 a.m. So the defendant will remain in the custody of the Broward Sheriff's Office until such time as he's sentenced.
Thank you, Your Honor.
Is there anything else for today?
Nothing from the defense, Your Honor.
Okay, thank you. We're in recess.